All right, Wednesday, federal judge signed an order. 312 messages, one night. Trump's personal devices, full forensic imaging authorized. According to court documents filed Thursday, this isn't a request anymore, it's happening. I've been going through the 47-page ruling. Here's what I found. This goes beyond anything we've seen in the document retention cases. We're talking complete digital reconstruction of communications from a specific 11-hour window. You saw the headlines about the message count. What they're not covering, the technology the forensics team is using and what it can actually recover. Let me show you. Quick context. Donald Trump, former president, currently facing multiple legal proceedings involving classified document handling and retention requirements. The issue? Prosecution alleges systematic deletion of communications during a critical period when preservation orders were already in effect. Timeline, fast version. Weeks back, subpoena issued requiring preservation of all electronic communications related to document storage and transfer. Days later, initial compliance filing submitted claiming full cooperation. Last week, forensic preliminary scan reveals massive gap in communication records for one specific overnight period. Wednesday, Judge Amanda Kensington grants prosecution's emergency motion for complete device imaging. That's the setup. Now the documents. The filing doesn't just authorize a look at deleted texts. It authorizes what digital forensics experts call deep extraction. Every keystroke, every draft, every autosave, every background process. 4 devices, 2 phones, 1 tablet, 1 laptop, all from the same night, June 13th into June 14th of this year. Okay, the evidence. First document, filed Thursday. I pulled page 23. It says, quoting here, respondents' devices show 312 discrete communications initiated or received between 2147 and 0823, of which 287 are no longer accessible through standard recovery methods. That's not my take. That's the filing. What it means? Over 90% of that night's messages are gone. Deliberately or not, gone. But here's what got me. Page 31, different section. The forensic preliminary report identifies 17 separate deletion events across the 4 devices. Not one bulk delete, 17 different actions. Put those together, yeah, someone spent time on this. I went through this section 4 times. Patterns clear. Deletions occurred on all devices within a 23-minute window. Each device shows use of secure deletion software not present in prior scans. Metadata indicates deletions happened while devices were in a specific location. Bedminster, New Jersey. All documented. Now, what nobody's covering. The filing reveals prosecutors already recovered fragments through cloud backup intercepts. 37 partial messages from the 312 total. Read that again, they already have pieces. The forensic imaging isn't phishing, it's filling gaps in what they've already reconstructed. Page 18 shows the preview. One recovered fragment, timestamp 2314, includes the phrase, documentation movement schedule adjusted per discussion. Another fragment, timestamp 147, contains a contact name, redacted in the public filing, and the words, confirm all copies accounted for. Third fragment, timestamp 612, just 4 words visible. Nothing remains at location. Fallout. Judge authorized imaging within 72 hours. Prosecution gets complete access to forensic findings. Defense gets simultaneous copies, but cannot block the process. Within 6 days from now. The order specifically authorizes recovery of, quote, deleted, overwritten, or encrypted materials using, quote, any lawful technical means available to certified federal digital forensics examiners. Translation, everything, including things Trump's team thought were permanently gone. One more thing. The filing includes a declaration from a senior digital forensics examiner at the FBI's Operational Technology Division. 12 years experience, former NSA. His declaration, page 8, states modern forensic tools can recover, quote, substantially all electronic activity from devices even after sophisticated deletion attempts. He specifically mentions recovering drafts that were never sent, autocomplete predictions based on typing patterns, and even voice-to-text conversion logs. Not just what was sent, what was almost sent, what was thought about sending. That's the evidence layer prosecutors are building. That's just the first document. Subscribe. I'm not done. There are 3 more filings in this case that dropped yesterday, breaking down all of them. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team says this is a Fourth Amendment overreach wrapped in a politically motivated fishing expedition. And honestly, some of it holds up. Their argument, the warrant authorizes access to personal devices covering periods and communications completely unrelated to the alleged document violations. The forensic scope is unlimited, potentially exposing privileged attorney-client communications, personal family matters, and unrelated business dealings. Senior defense counsel James Trusty put it this way: this isn't an investigation, it's a digital strip search of a former president's entire electronic life. Don't agree with all of it, but that's not nothing. What they've got: legal precedent limiting forensic searches to specifically identified materials relevant to charged conduct. Arguments that one night of communications can't justify imaging devices containing years of data. Even the judge's order admits concerns. Page 4 includes language requiring prosecution to use a filter team, independent attorneys who screen materials before lead prosecutors see them, blocking anything privileged or irrelevant. Like, I'm not here to tell you who's right. Prosecution's interpretation, the preservation order was clear, violations were systematic, and forensic imaging is the only way to establish the complete timeline. Defense interpretation? This is exactly the kind of invasive government overreach the Fourth Amendment prevents, especially when applied to political figures. Both can be true. That's what makes this complicated. Privacy advocates are watching this closely too. Electronic Frontier Foundation filed an amicus brief Wednesday raising concerns about the precedent. Their point: if this level of forensic access becomes standard in document retention cases, it could apply to anyone: corporate executives, journalists, activists. Constitutional law professor Rachel Barco at NYU wrote in a legal analysis, the question isn't whether evidence exists, it's whether this method of obtaining it survives constitutional scrutiny. That's the legitimate tension here. On one hand, if someone systematically deleted evidence after a preservation order, what remedy does the government have? Just accept the deletion? On the other hand, does recovering that evidence justify unlimited access to every digital artifact on those devices? Courts have gone both ways, depending on circumstances. What I can tell you, what the documents show. And they show Judge Kensington found probable cause that, quote, evidence of deliberate destruction exists, and that forensic imaging is, quote, narrowly tailored to the specific time frame under investigation. Her words. Page 6. Whether that standard holds up on appeal, we'll see. This didn't come out of nowhere. Backstory quick. Months ago, Trump attorneys certified full compliance with document retention requirements in ongoing federal proceedings. Weeks later, routine metadata analysis revealed suspicious gaps in communication logs during critical periods. Days before the current order, prosecutors filed a sealed motion alleging evidence of systematic evidence destruction. Someone even said, on record in a prior deposition, all requested materials were preserved in accordance with standard procedures. What happened? Those standard procedures apparently didn't cover secure deletion software. Pattern across the previous cases. Compliance certifications filed. Later evidence suggests incomplete or misleading disclosures. Prosecutors request escalated discovery methods. Every time before this, Courts allowed limited additional discovery, but stopped short of full device imaging. This time different. The specific evidence in Wednesday's filing apparently crossed a threshold previous motions didn't reach. 17 deletion events, specialized software, tight time frame, fragmented messages already recovered showing substance relevant to the investigation. That combination, Judge Kensington found it sufficient. Until Wednesday, defense strategy seemed to be working. Narrow the scope, challenge every expansion, delay forensic access. Not anymore. Following the trail, hit like. This gets more technical. I'm breaking down what the forensics team can actually do with these devices. Data recovery methods most people don't know exist. Wednesday, 3:47 p.m. Here's what happened. Judge Kensington issued the order from chambers. No hearing, written decision only. Motion for forensic imaging is granted. Respondent shall make devices available for examination within 72 hours. Courthouse quiet. Then phones lit up. What followed? Defense filed emergency motion to stay within 90 minutes. Prosecution opposed within 3 hours. Judge denied the stay by end of business day. 6 hours. That fast. Now. What everyone missed. While people focused on the 312 messages, something else happened. Judge Kensington's order includes a separate provision authorizing imaging of any device used to access or manage the identified accounts during the specified time frame. That language is broader than the 4 devices named in the original motion. Then Thursday morning, prosecution filed a supplemental notice. They've identified 2 additional devices that access the relevant accounts that night: a desktop computer at the Bedminster residence and a secondary phone. 6 devices total now. Defense response: emergency appeal to the circuit court. Wasn't reactive, calculated. You can see it in their appellate brief filed Friday morning. They'd been preparing this, citations ready, precedent lined up, constitutional arguments polished, 73 pages, filed 16 hours after the imaging order. They knew this was coming and had the appeal drafted in advance. This is where it gets interesting. The circuit court hasn't ruled on the stay request yet. That means unless they intervene by Monday, the forensic examination starts regardless. Devices in FBI custody as of yesterday morning. Don't go anywhere. What I show next changes the picture. The forensic methods they're using, this isn't just recovering deleted texts. It's different. What are experts saying? Former FBI supervisory special agent in cyber division, 19 years experience. Modern device forensics can reconstruct activity most people assume is permanently erased. We're not talking about standard data recovery. Plain English, even sophisticated deletion leaves traces. Another one, chief technology officer at a digital forensics firm that works federal cases. Secure deletion software overwrites data, but it can't eliminate metadata, system logs, or artifacts in unallocated space. Timestamps survive. Communication patterns survive. Key there, it's not just message content. It's the digital fingerprints around the messages. Here's what's interesting. Even a defense digital forensics expert who submitted a declaration for Trump's team admits complete elimination of forensic artifacts requires technical expertise beyond typical user capability. When both sides agree, pay attention. Consensus among the digital forensics community: deleted messages from modern encrypted messaging apps leave recoverable traces in device memory. Cloud backup intercepts often capture data before local deletion occurs. Communication metadata provides timeline reconstruction, even without content. That's where professionals land. Former assistant U.S. attorney specializing in digital evidence, now in private practice. The real question isn't whether they'll recover data. It's whether what they recover is admissible and whether it proves intent. That's the legal layer on top of the technical layer. Constitutional law professor who filed analysis with the court, forensic capability has outpaced Fourth Amendment doctrine. Courts are still developing standards for this technology. Two separate conversations, one technical, what can be recovered, one legal, what should be allowed. Both matter here. Useful breakdown? Like it. I'm covering the technical process step by step. What actually happens when federal forensic examiners image a device? Most detailed explanation you'll find. Why should you care? Real talk, how this affects actual people. This sets a precedent. Next time you're involved in litigation, employment dispute, divorce, business conflict, and there's a document preservation order, rules changed. Quick example. You're in a workplace discrimination case. Company issues a litigation hold. You delete some texts you think are personal and unrelated. Opposing counsel finds gaps in your message logs, files a motion for forensic imaging of your phone. Not dramatic. Based on the standard Wednesday's ruling establishes, that motion might get granted. Your entire phone, work and personal, imaged and analyzed. If you use encrypted messaging apps, thinking deletion means gone, pay attention. Signal, Telegram, WhatsApp all leave forensic artifacts that specialized tools can recover. Not talking about the apps being insecure, they're secure against interception. But local device forensics is different. That's examining the physical device after the fact. What's some privacy-conscious people doing? Using devices that never connect to cloud services and physically destroying devices when litigation risk exists. Not advice, just what I'm seeing in corporate contexts. Right now, anyone in federal litigation with electronic discovery obligations. Corporate executives already adjusting document retention policies. 3 major companies announced revised electronic communication policies this week, specifically citing evolving forensic capabilities. Hits within normal business operations. Uncomfortable part. If you're in any situation where your communications might become relevant to a legal proceeding, and you've deleted things after being told to preserve them, you're potentially exposed to exactly this kind of forensic examination. That's not limited to high-profile political cases. Happens in securities litigation, intellectual property disputes, employment cases, divorce proceedings. If you have a smartphone and you're in litigation, you're part of this evolving legal landscape. Not trying to scare you. That's what the technology and legal standards suggest. What informed people doing? Treating litigation holds as absolute. No deletion of anything, even clearly personal materials, once preservation notice received. Consulting with attorneys before using any secure deletion tools if litigation risk exists. Asking their lawyers, what's our policy if we get a forensic imaging motion? Knowledge helps. Courts are developing these standards in real time. Wednesday's ruling is one more data point in how far forensic access can go. Better to understand the landscape than learn about it when you're the respondent. How'd Trump's team respond? Made it worse. Honestly, Thursday afternoon press statement called the order digital tyranny and third world country tactics. Quote, they want every private communication, every family text, every business discussion. This is what authoritarian regimes do. Reaction from legal analysts? Constitutional scholars noted the irony of Fourth Amendment objections from someone who previously advocated for expanded surveillance powers. 3 former Trump administration officials publicly disagreed with the characterization, stating federal forensic standards include robust privacy protections. Conservative legal commentator and former federal prosecutor came back. The filter team process exists specifically to protect privileged and irrelevant materials. This isn't a free-for-all. Then Friday, Trump posted on social media that he's already won this fight, because they'll find nothing because there's nothing to find. Legal experts noted that statement could complicate any future argument that the imaging was unnecessary or overly burdensome. Defense attorneys generally advise clients not to characterize evidence before it's examined. Not cooling down, heating up. Saturday morning, multiple conservative legal foundations announced they're filing supporting briefs in the Circuit Court appeal. This is becoming the test case for digital forensic limits. What's still unclear? One, whether the Circuit Court will stay the imaging process pending appeal. Two, what the filter team protocol actually looks like in practice, how they distinguish relevant from privileged materials when everything's mixed together on the same devices. Coming. Circuit Court has oral arguments scheduled Tuesday, July 7th on the emergency stay motion. Trump's legal team reportedly preparing a parallel petition to the Supreme Court if the circuit denies the stay. Forensic examination team standing by at FBI's Operational Technology Division facility in Quantico. Date to watch Monday, July 6th. If no stay is issued by then, imaging begins regardless of pending appeals. Should know more by then. Prosecution has indicated if they get the forensic access, preliminary findings could be ready within 3 weeks. Not the full analysis, but enough to know what was deleted and when. Defense has already announced they'll challenge admissibility of anything recovered, even if the imaging proceeds. Subscribe. I'll cover the Circuit Court hearing when it happens. Tuesday's oral arguments will determine whether this imaging proceeds or gets paused pending appeal review. Where we are right now. 6 devices in FBI custody, held in secure facility, pending court authorization to begin imaging. Defense emergency appeal pending before Circuit Court. No stay currently in place. Imaging authorized to proceed. Scheduled. Tuesday, July 7th, Circuit Court oral arguments on stay motion. Monday, July 6th, deadline for imaging to begin if no stay issued. Friday, July 10th, prosecution's deadline to file status report on whether examination has commenced. Not public yet whether Trump will personally appear at Tuesday's Circuit Court hearing or rely solely on counsel. Also developing, 3 outside organizations have filed motions to intervene or submit amicus briefs, 2 supporting Trump's privacy arguments, 1 supporting the government's forensic access. Clock's running. If imaging begins Monday, the technical process takes approximately 4 to 7 days, depending on device storage capacity and encryption complexity. After that, filter team review. After that, prosecution gets access to whatever survives the privilege screening. Timeline puts us at late July for any substantive findings. That's where we are. Trump fighting the forensic order on constitutional grounds while his devices sit in FBI custody. Surface read, another political battle over document retention. But the technology being deployed here represents the cutting edge of federal digital forensic capability. Most criminal defendants don't face this level of examination. Question isn't whether Trump deserves it. Question is whether the legal standard justifies it, and whether that standard, once established, gets applied more broadly. I'll be watching the Circuit Court's reasoning Tuesday, not just the outcome, the legal framework they use to evaluate digital privacy against evidence preservation. Story's not over, still developing. Subscribe for the full picture, not just headlines. When the Circuit Court rules, I'll break down the decision. When forensic findings emerge, if they do, I'll analyze what the technology actually revealed versus what gets reported. This intersection of constitutional law and digital forensics is defining how evidence works in the modern era. Talk soon.